Hey folks, welcome to today's Law of Self-Defense ongoing coverage of the Kyle Rittenhouse trial. I am, of course, attorney Andrew Branca for Law of Self-Defense, and this third day of the trial was perhaps the worst yet for prosecutor Timothy Binger's efforts to have Kyle Rittenhouse convicted and sentenced to life in prison for having shot three men, two fatally, the night of August 25th, 2020 in Kenosha, Wisconsin, when the city was suffering a tsunami of rioting, looting, and arson following the lawful shooting of a knife-wielding Jacob Blake by Kenosha police officers. And that's really saying something, because it's not like the prosecution outperformed in the first 2 days of the trial. Indeed, coming into today, the state had yet to present any evidence that was substantively inconsistent with Kyle's legal defense of self-defense. None. Today, however, was even worse. Two of the state's own witnesses, and arguably their star witnesses with the greatest immediate personal knowledge of the events surrounding the shootings, journalist Richard McGinnis, who was filming and interviewing Kyle that night, and former Army infantryman Ryan Balch, who was also armed along with Kyle that night, they provided a lengthy testimony that not only failed to assist the state's efforts to attack Kyle's claim of self-defense, their testimony substantively strengthened that claim of self-defense. Now, we'll dive into their testimony in just a moment. Before I do, however, I ought to mention that juror number 7 was dismissed from the jury panel today for cause, apparently for being idiotic enough to attempt to tell a Jacob Blake joke to a bailiff. When questioned by Judge Schroeder about this morning, the juror refused to repeat his joke, but apparently it went along the lines of, why did the police shoot Jacob Blake 7 times? Because they ran out of bullets. So away with juror number 7. By the way, as always, in the text version of today's content, we do embed the relevant video from those portions of the trial that match up with what I'm talking about. If you're listening to this on audio or watching this as video, we don't embed those components into the audio or video. They'd all be 12 hours long. But if you'd like to see the relevant video, watch for yourself, make sure I'm describing things accurately, you can go to the text version of our content and always find the courtroom videos embedded there. Before I jump into the analysis of today's legal proceedings, I do want to mention our sponsor, CCW Safe, a provider of legal service memberships. What many people mistakenly call self-defense insurance. In effect, they promise to pay their members' legal expenses if the member is involved in a use of force event, and those expenses get big fast, folks. If you've had to shoot someone in self-defense, they die, you're charged with murder or manslaughter, it's easy to burn through $200,000 before you even get the trial. So if you don't have that kind of money stuffed in a mattress, it can be helpful to have a partner standing behind you with the resources you need to fight the legal battle the way you want it fought, as if the rest of your life depends on it, because really it does. I've looked at all the companies that offer these kinds of services. As you might imagine, I found that CCW Safe is by far the best fit for me. I'm personally a member. Whether they're the best fit for you is something only you can decide, but I do urge you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member there, you can save 10% off your membership with the discount code LOSD10, that's LOSD for Law of Self-Defense, and the numeral 10 at lawofselfdefense.com/CCWSafe. Now, before I dive into the individual testimony of state witnesses Richard McGinnis, a videographer for the Daily Caller news organization, and Ryan Balch, a manufacturing worker and former Army infantryman, it's worth reminding ourselves what their testimony ought to have looked like had this been a normal criminal prosecution based on actual legal merit. As two state witnesses, not defense witnesses, both McGinnis and Balch would be expected to provide testimony that contributed to the prosecution's narrative of guilt and undermined the defendant's legal defenses. In this case, that largely boils down to attacking and destroying Kyle's legal defense of self-defense, at least with respect to all the felony use of force and reckless endangerment charges in this case. Now, Kyle Rittenhouse is presumed innocent, and that means that his shooting of the three men and the reasonableness of his conduct otherwise, the night of August 25th, 2020, is presumed to be justified as lawful self-defense, unless the state can disprove self-defense beyond a reasonable doubt. Now, the prosecution doesn't have to disprove Kyle's claim of self-defense in its entirety. The prosecution merely needs to disprove any one of the 4 elements that make up that claim of self-defense. These 4 elements are cumulative, meaning every one of the 4 is required. So if even a single one is disproven beyond a reasonable doubt, Kyle's legal justification of self-defense collapses entirely. To those who are new to self-defense law or would just like a quick refresh on the concepts of the elements of self-defense, here are the 4 elements relevant to the facts of this case and the law of Wisconsin, and how the state would typically be expected to attack and disprove them. The first element is innocence. The state might attempt to prove that it was Kyle who was the initial unlawful aggressor in any of the confrontations he was in that night. The second element is imminence. The state might attempt to prove that the attacks Kyle was defending himself against were neither actually in progress or immediately about to occur. The fourth element is proportionality. The state might attempt to prove that the attacks on Kyle did not present as apparently deadly force in nature, meaning readily capable of causing his death or serious bodily injury, and that therefore his own use of deadly defensive force was excessive. And the fourth element is reasonableness. The state might attempt to prove either that Kyle lacked a genuine belief in the need to act in self-defense, or that this belief was irrational and not objectively reasonable under the circumstances. And of course, whichever element or elements the state sought to target in its attack on Kyle's claim of self-defense, it would need to disprove that element beyond any reasonable doubt. Now, this is necessarily the mission of Assistant DA Binger in this prosecution of Kyle Rittenhouse, and how that mission would be accomplished. And it needs to be accomplished during the state's presentation of evidence. Obviously, after the state has rested and the defense gets its turn, it's not as if the attack by the defense is going to make the state's narrative stronger. So as I listen to the state present its witnesses and subject them to cross-examination or questioning, what I'm looking for is the building out of that narrative of guilt, that destruction of self-defense, the substantive attacks on one or more of those 4 elements. What is this testimony, this line of argument, attacking exactly? Is it attacking innocence, imminence, proportionality, reasonableness? Because that's all that really matters. Any testimony or argument by the state that doesn't have any one of those elements as its target, that does not substantively undermine and disprove any one of those elements beyond a reasonable doubt, is nothing but wasted effort and time. What I saw over the first 2 days of this trial was a bunch of testimony that contributed nothing substantively to downgrading any of those 4 elements, and thus nothing to disprove Kyle Rittenhouse's claim of self-defense. There was simply no substantive evidence that undermined any of those 4 elements of Kyle's self-defense claim. What I saw from the state's witnesses today, however, was far worse for the state. Not only did their testimony, the testimony which is supposed to be the building blocks for the destruction of the claim of self-defense, not only did their testimony not undermine Kyle's claim of self-defense, much of today's testimony actually strengthened Kyle's claim of self-defense. And perhaps even worse, Prosecutor Binger's attempts to badger the witness's testimony into something that might, in one's wildest imaginings, resemble a tool to bludgeon self-defense resulted only in him appearing intellectually desperate and in his witnesses becoming visibly resistant to his badgering. In the case of Balch in particular, Prosecutor Binger was even brought to the extremity of suggesting to the jury that Balch, Binger's own witness, whom Binger himself had called to the witness stand, was nothing more than a petty liar. With that said, let's dive in. First, state witness Richard McGinnis and his resistance of the hostile badgering of Prosecutor Binger. Now, McGinnis is a videographer who works in support of journalists for the Daily Caller news organization, essentially securing the video and photo content that the journalists use to guide, buttress, and flesh out the news stories they write about, notable events. That's his profession, and he has frequently over the years engaged in his craft in the midst of violent protests, including in Seattle, Portland, New York, Washington, D.C., and elsewhere, and that was precisely what McGinnis was doing in Kenosha on the night of August 25th, 2020, having flown into town for that purpose the previous day. He would spend the nights of August 24th and 25th wandering around the streets of Kenosha, pursuing his craft, and on the night of the 25th, one of his primary subjects was no other than Kyle Rittenhouse. As it happens, also captured by McGinnis was Ryan Balch, the second star state witness of the day who worked alongside Kyle to present as an armed presence on the streets of Kenosha for the purpose of protecting property and persons, and I'll address Balch's testimony separately here. Much of McGinnis's testimony centered around video he had made while following Kyle and Balch around Kenosha the night of the 25th, including capturing interview-like conversations with them. Also important was McGinnis' presence in close proximity to Kyle when Joseph Rosenbaum launched his ill-fated attack on the 17-year-old. This event was not video recorded by McGinnis, but was nevertheless personally observed by McGinnis. Because of the importance of the McGinnis video of Kyle and Balch, it was played repeatedly and at length by Prosecutor Binger. But to what purpose, I could not imagine, because it did nothing to further the state's core mission of disproving any one of the elements of self-defense beyond a reasonable doubt. If anything, it served to present Kyle as polite and caring and non-confrontational. Repeatedly, we see Kyle walking down the street alongside Balch, with neither man presenting in a threatening manner in the slightest. To the contrary, they are each continually calling out to see if others, whether their own colleagues or protesters alike, are in need of medical attention, which is, of course, Kyle's primary purpose for being present in Kenosha that night. At one point, a protester screams at Rittenhouse, "F you!" Kyle's response, "I love you too, ma'am." When Balch recounted this event from the witness stand, someone in the courtroom, I don't know who, hopefully not the judge, actually laughed out loud. At one point in the McGinnis video, we see Kyle and Balch encounter a group of punk rockers with fire extinguishers who are acting as a fire brigade, and one of them reports having been shot. Kyle immediately attempts to offer medical care, only to discover the person has been shot with a rubber bullet with no great effect. And Kyle, Balch, and the punk rockers end up laughing and joking about the whole affair, with everyone being very friendly. A few moments later, Kyle, with McGinnis recording beside him, comes across a group of 4 young black men, and this encounter is quite different. The group immediately displayed hostility towards Kyle and McGinnis. Kyle, seeing this, does not engage or threaten in any way. Instead, he simply turns and walks away, calling out once again for anyone who might need medical care. That this group of 4 young men was genuinely threatening became incontestable when McGinnis described his own efforts to chat with them. He testified that one of the men immediately stepped forward with a rock in a raised hand in a manner McGinnis could only interpret as an intent to bash the rock into his skull. McGinnis immediately jumped backwards to secure his safety and then offered the men an alcoholic beverage he carried in his backpack specifically for the purpose of tribute to be offered to diffuse such hostile encounters. Prosecutor Binger noted that McGinnis had used the word menacing when he spoke in an interview after Kyle's shooting, within 3 days, I think, and the prosecutor repeatedly attempted to badger McGinnis into testifying that he meant this term to apply to Kyle himself, that McGinnis found Kyle to be personally menacing. First, this is hardly credible, given that McGinnis chose to follow around the armed Kyle and Balch for quite some time the night of the 25th. He didn't do the same, for example, with the actually menacing group of 4 young black men he'd encountered. Second, McGinnis consistently responded to Binger's badgering suggestions by making clear that the word menacing was intended as a description of the circumstances generally, as in any potentially violent protest environment, not of Kyle personally. In other words, Binger wanted McGinnis to testify that he was using menacing to refer to Kyle as threatening. Instead, McGinnis made clear he was using menacing to merely simply mean the increased risk of being in an environment where guns were being carried around by people generally. Prosecutor Binger also attempted to get McGinnis to testify that there was something highly unusual and unreasonable about someone at a protest openly carrying firearms. McGinnis answered that no, he'd often seen people with firearms at protests, but just handguns, right? Not AR-15s, suggested Binger. Oh, usually handguns, but sometimes rifles, McGinnis answered. But surely not the combination of rifle and a medic kit, followed up Binger. Well, no, conceded McGinnis. He couldn't say he'd seen that particular combination before. I mean, frankly, it was all nonsense. If McGinnis had seen such a combination before, rifle and medic, presumably Binger would have continued to narrow the characteristics he was defining until he managed to exclude this specific defendant from McGinnis's prior experience. I suppose the next variation of the question would have been, but surely not the combination of rifle, medic kit, and the first name Kyle, right? At some point, McGinnis and Kyle had become somewhat separated, and then McGinnis saw the now familiar Kyle run with a fire extinguisher through his line of sight, and he decided to follow to see what was going on. As it happens, Kyle was running down Sheridan Street to put out a fire, reportedly occurring in a car source parking lot down the street. As Kyle approached the lot, he also happened to be gaining ground on Joseph Rosenbaum, who was ahead up in the street. Rosenbaum was accompanied by Joshua Zeminski and his wife, Mrs. Zeminski, with whom Rosenbaum was apparently friends. Joshua Zeminski was carrying a Glock pistol, which he would shortly fire into the air, triggering the subsequent events resulting in the death of Rosenbaum and Anthony Huber and the maiming of Gage Grosskreutz. As Kyle reached the edge of the car source lot, Rosenbaum concealed himself among 4 cars, then emerged behind Kyle and initiated his charge of Kyle. McGinnis was still running down Sheridan to catch up with Kyle, and so ended up behind Rosenbaum as events proceeded. And also roughly behind Kyle and Rosenbaum was Joshua Zeminski, who was on the sidewalk near the group of 4 cars that Rosenbaum had been hiding in. As Rosenbaum chased the isolated Kyle across the lot, Joshua Zeminski raised his pistol, fired a shot in the air. The fleeing Kyle, hearing the shot behind him, turned to look in that direction, and so Rosenbaum charging at him, screaming, "F you," at the top of his lungs. Now, much of this was confirmed both by the observational testimony of McGinnis, as well as, of course, by various video recordings, including the FBI aerial infrared video recording. So these events are effectively indisputable. McGinnis personally observed the charge of Rosenbaum on Kyle and described the attack in some detail. Rosenbaum was in a hunched forward running position, as one would be running as fast as one could. Kyle was desperately fleeing towards the far side of the car source lot and was shouting, "Friendly, friendly, friendly," while doing so. These cries of friendly did not dissuade Rosenbaum's continuing charge. When Kyle turned slightly back towards Rosenbaum, even as Kyle continued to retreat, but placing his rifle well within Rosenbaum's view, although pointed in a safe direction, the sight of the rifle did not dissuade Rosenbaum's charge. Indeed, Rosenbaum would charge until he was close enough to lunge with outstretched arms for possession and control of Kyle's rifle. Kyle was still holding his rifle at a low ready, approximately at a 45-degree angle to the ground. McGinnis actually stood up from his witness chair to demonstrate these aggressive attacking motions by Rosenbaum, and he did so at the request of Prosecutor Binger. At the last moment, however, Kyle managed to turn slightly away from the lunge so that Rosenbaum's outstretched hands failed to grasp control of the weapon, and that's when Kyle fired 4 rounds in 0.76 seconds. As Rosenbaum made his final diving lunge, Kyle had the rifle leveled at Rosenbaum, but this still meant at a downward angle, giving Rosenbaum's low position. So the rifle was not, for example, level with the street when it was fired. Now, one of those 4 rounds, the one the medical examiner will purportedly claim was the fatal shot, ended up striking Rosenbaum in his back. And this was almost certainly a consequence of the manner in which Rosenbaum chose to attack the rifle-armed Kyle, using a low, diving, lunging motion. Prosecutor Binger, however, was determined to have McGinnis testify that Kyle had simply shot Rosenbaum in the back, as if in an act of cold malice, he had shot Rosenbaum in the back as Rosenbaum was walking away from Kyle, or that Kyle had intentionally shot Rosenbaum as he was helplessly falling to the ground and no longer a threat of any kind. Prosecutor Binger helpfully suggested when the defendant shot Rosenbaum, he was already falling. "No, not falling," answered McGinnis. "It was just his charging speed and lunging motion was carrying him forward." Binger objected. "But you gave a television interview in which you said that the defendant shot Rosenbaum as he was falling." McGinnis answered, "I don't remember ever saying that. Is that a direct quote?" Of course, Binger had the interview recording, and now he used it to effectively treat McGinnis, his own cooperating witness, as if the videographer were a hostile witness, implying that McGinnis was lying to the jury under oath. McGinnis explained that the shots happened very quickly, that Rosenbaum was lunging. For all he knew, it was the first shots that caused the falling motion, rather than the falling motion preceding the shots. Now, McGinnis may not know this, but the first 2 rounds did in fact hit Rosenbaum's thigh and pelvis and likely did compel Rosenbaum's fall. Well, you're saying that now, said Binger, but wouldn't your memory be better a mere 3 days after the event when you gave this interview than it would be now? Folks, this is how one treats a hostile witness whose current testimony in court you're seeking to impeach. Binger tried again. Your statement in this interview is different than what you're telling us now. You said in the interview that Rosenbaum was falling when the defendant shot him. McGinnis answered, I would not say that the defendant shot Rosenbaum as he was falling. I would not use that word falling. I'm not saying that. Binger said, but you said in the interview, McGinnis responded, I'm not saying that now. At that point, Judge Schroeder had had enough and interrupted Binger's questioning of his own witness, telling Binger effectively that he was not to tell the witness what the witness was saying. McGinnis, for his part, denied any inconsistency between his interview statement and his court statement. Kyle shot Rosenbaum as Rosenbaum was lunging forward to grab control of Kyle's rifle, was shot, and then ended up face down on the street. Now, at that moment, the proceedings mercifully took a break for lunch, but that didn't help poor Prosecutor Binger any. After lunch, Prosecutor Binger kept up his direct examination of McGinnis, now focusing on the supposed reckless endangerment charge, which McGinnis is the purported victim of. In the criminal complaint, there's a sworn claim that some object, presumably a bullet fired by Kyle, had actually struck McGinnis in the leg. McGinnis would have none of that in his testimony, however. He clarified that he wasn't even sure if the sensation he'd felt on his leg was the result of the impact of an object or just a sensation resulting from the sound of the gunshot or what. But when he looked, he hadn't suffered any physical injury of any kind. Okay, folks, those are the highlights of direct examination by Prosecutor Binger of his own witness, McGinnis. There is much more, of course, including a lengthy series of softly asked questions about McGinnis's efforts to provide care to the fatally wounded Rosenbaum, none of which has any relevance to Kyle's self-defense claim. Note that all the substantive testimony by McGinnis on direct was either not relevant to Kyle's self-defense claim, not damaging to that claim, or actually helped Kyle's claim of self-defense. And that was before the defense got their hands on McGinnis in cross-examination, which is what happened next. So Attorney Richards, all he really had to do was get McGinnis to repeat his substantive relevant testimony from direct because it was all helpful to Kyle's claim of self-defense, but Richards managed more than that. In your police interview, Richards noted, you indicated it was not only Rosenbaum pursuing Kyle, but that there were other people whom Kyle was attempting to evade. In other words, that Kyle was threatened by multiple pursuers. Now, ultimately, this would turn out to be more a matter of McGinnis perceiving the attention of others focused on Kyle among people who were already traveling down the street in the same direction as Kyle, rather than additional people charging at Kyle as Rosenbaum had done. Nevertheless, either the jury bought the suggestion of increased threat to Kyle by multiple aggressors, or it was a wash, helpful, neutral, not damaging. Richards also touched back on the menacing point, which was drawn from another interview McGinnis had done shortly after the events of that night. Now, when you say menacing, you mean the circumstances were menacing, right? Not Kyle in particular. McGinnis answered, I meant the situation. If anything, the people on the roof, not so much the people on the ground, where, of course, Kyle was. Richards asked, and in that interview, you mentioned menacing. That interview was 26 minutes long, and you said the word menacing once. Yep, agreed McGinnis. Finally, Richards also had McGinnis step through the final series of events that resulted in Kyle shooting Rosenbaum. Kyle was fleeing across the parking lot, seeking safety, but coming upon what to McGinnis appeared to be a dead end. A shot came from behind Kyle, fired by Rosenbaum friend Zeminski, and when Kyle looked back, he saw Rosenbaum charging at him. Kyle shouted, friendly, 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 and Rosenbaum shouted, F you! Kyle had the gun at a safe, low-ready position when Rosenbaum dove for the gun, hands outstretched to seize control of the weapon, and that's when Kyle finally fired 4 rounds. Sounds like self-defense to me. Now, there's more good stuff in the cross-examination, but those are the highlights of it. Now, perhaps the highlight of McGinnis' testimony, however, was the result, again, of prosecutor Binger during his redirect questioning of him. Binger had been very unhappy when McGinnis was allowed to suggest during cross-examination that it had been the intent of Rosenbaum to seize Kyle's rifle. Binger objected at the time, but Judge Schroeder overruled the objection. Now on redirect, Binger rather heatedly challenged his own witness. You can't read Rosenbaum's mind, right? You can't know what he was actually thinking, right? Your interpretation of his intent is nothing but complete guesswork, isn't that right? And McGinnis paused for a moment and replied, well, he said F you, and then he reached for the weapon. So maybe it's not entirely guesswork, I would say. Again, there's more to it, but those are the highlights. So that brings us to state witness Ryan Balch. So Ryan Balch first met Kyle Rittenhouse the night of August 25th when they both showed up independently to Kenosha and ultimately the Car Source lot to attempt to protect property and provide medical care to the injured. Both men came armed with AR-style rifles, but that was about the only similarity, whereas Kyle was a 17-year-old lifeguard who'd fired his rifle on one previous occasion. Balch was a former Army infantryman who had done a tour in Afghanistan and a tour in Iraq and had put 10 to 15,000 rounds through the AR rifle he had owned for years, now in part because apparently he uses the rifle competitively. Once again, Balch's testimony from, I remind you, a state witness was extremely helpful for the defense and extremely harmful to the prosecution. For example, Balch would testify that although he'd come to Kenosha wearing a plate carrier, a kind of body armor, and carrying an AR-15 rifle and a Glock pistol, it turned out that he never actually had to use any of that stuff. The mere presence of armed persons like himself and Kyle proved sufficient to prevent the kind of catastrophic rioting, looting, and arson the city of Kenosha had suffered the previous night. In other words, Kyle showing up to Kenosha with a rifle was a social good, not the act of a maniacal gun nut intent on murdering people. When Prosecutor Binger asked Balch for his impression of Kyle that night, Balch replied that Kyle seemed like a young and impressionable kid, interested in other people and a lifeguard seeking to provide medical care to anyone who might be injured. He also described Kyle as presenting as vulnerable, as someone who protesters might identify as a target and attack. In contrast, when Prosecutor Binger asked Balch, his own witness, for his impression of Joseph Rosenbaum that night, Balch replied that every time he encountered Rosenbaum, he was being hyper-aggressive and acting out in a violent manner, always having to be restrained from violence by others. Indeed, Balch said he was approached by other protesters who wanted to assure him that Rosenbaum was not one of them, not a member of their group. These other protesters wanted no misunderstanding that there might be an association with the hyper-aggressive Rosenbaum and themselves. The ultimate high point, however, came, and again, I feel obliged to remind you, this is while the state is engaged in direct questioning of their own witness. The high point came when Prosecutor Binger asked Balch to describe an encounter between Kyle and Balch, on the one hand, and Rosenbaum on the other, that took place shortly after Kyle had put out a dumpster fire started by Rosenbaum. Balch testified that Rosenbaum came right up to the pair, got right in my face, yelling and screaming, and murderously pledged, if I catch any of you guys alone tonight, I'm going to effing kill you. Well, it's worth recalling, I think, that this murderous threat from a hyper-aggressive and patently violent Rosenbaum came only a short time before Kyle, running for his life, would hear a gunshot behind him and see a charging Rosenbaum screaming F you at the top of his lungs and lunging for control of Kyle's rifle. If that sounds to you like a pretty sound basis for a shooting of Rosenbaum in self-defense, I'd have to agree. To this absolutely catastrophic testimony, Prosecutor Binger could do little but flail. Did you actually see Rosenbaum actually injure anybody? No, Balch replied, though I did see him set fires, a dumpster fire, and lots of other little fires all up and down the street. Then, remarkably from Prosecutor Binger, besides the fires you saw him set, did you see him set any other fires? I mean, seriously, Prosecutor Binger? Is this the A game? He asked Balch, did you ever see Rosenbaum with a weapon? No. A gun? No. A knife? No. A bat? No. A club? No. Binger has become quite fond of this particular laundry list question. Of course, I would suggest that at the moment he was shot, Rosenbaum was actually in the process of arming himself with a gun, with Kyle's gun. when Kyle's bullet stopped him. At this point, Binger's direct examination of Balch seemed to go off in some netherworld, having nothing to do with anything relevant about the case. Lots of just what were you doing later in the day after the shootings. It was very mysterious, appeared to have zero relevance to anything of substance in this case, and it went on like this interminably. At one point, the defense finally objected, noting many of these questions currently being asked either weren't relevant or had been asked 40 minutes earlier. Even Judge Schroeder was getting a bit tweaked. "Where is all this going?" he asked Binger, who gave a rather non-responsive, hard-to-understand reply. "Why would any of that be relevant?" asked the judge, and Binger gave another non-responsive reply, at which point Judge Schroeder figuratively threw up his hands and just decided to have the court take a break. Humorously, during this recess, the cameras were deflected off to the side, as usual practice when the court is in recess, but the judge's microphone, however, was left live. And as a result, we got to overhear Judge Schroeder make casual conversation with his court clerk, and part of that conversation went along the lines of, "Man, this seems to be taking forever. How long has he been on the stand? How long? How about 2 weeks?" That's all Judge Schroeder. I'll include that clip because it's nice and short right here.
Oh, man. This seems like it's been going on forever. How long this has been on? This current witness, how long has he been on? How about 2 weeks?
When the court returned from recess, Prosecutor Binger once again set out to impeach his own witness and suggest to the jury that Balch was lying from the witness stand. "When you were approached by reporters that night, is it true you gave them a fake name?" "Yes," answered Balch, "to protect my identity." "You spoke to the police?" "Yes." "You wanted to tell them the truth?" "Yes." "You know lying to the FBI can get you in trouble?" "Yes." "Well, the FBI report of that meeting says that you told them Rosenbaum's plastic bag contained ammonia-like products for use in making tear gas, but you know that's not true, correct?" "Correct," answered Balch. And that was the end of the direct of Balch. But thankfully, Attorney Richards, who did cross-examination of Balch, kept it very succinct. I mean, really, almost all of the very, very lengthy direct questioning of Balch by Prosecutor Binger had been to the benefit of the defense. So what more was there for the defense to elicit from this witness on cross-examination? But Richards did want to address this impeachment attempt by Prosecutor Binger, and he did so swiftly and concisely. "Are you lying to this jury under oath right now?" he asked Balch. "I am not." "And this FBI report, this is not a document you get to review carefully and then swear to under oath, is it?" "Nope. In fact, you just chat with the FBI agents, they take some notes, and then they go off and write up this report in the manner they recall with the things they think most important." "Yep." And that was it for Ryan Balch. Now, before McGinnis and before Balch, there was also morning testimony from Detective Howard to complete his contribution to this travesty of a trial, continued from yesterday. Really, however, this was just an attempt by Prosecutor Binger to rehabilitate Howard on the failure to execute the search warrant on the Grosskreutz phone and the failure to record the Grosskreutz interview, both of which had happened, the phone seized and the interview recorded with every other witness in the case. It also gave Richards a chance to hit those points home again for the defense with the jury that these failures had occurred. So in conclusion, in yesterday's wrap-up, I wrote the following. I'm going to quote myself here. Quote, "Granted, we're only 2 full days into the state's case here, but I've yet to see any compelling evidence that seems capable of meeting their burden to disprove self-defense beyond a reasonable doubt, and I'm beginning to wonder if we ever will." Close quote. That was yesterday. Well, today was day 3 of the trial, and not only does that statement remain true, but if anything, the prosecution's narrative of guilt looks profoundly weaker, and the defense narrative of self-defense looks profoundly stronger than was the case yesterday. Okay, folks, that's it for tonight. Join me again tomorrow morning at Legal Insurrection for our live real-time streaming of the trial proceedings, as well as our real-time commenting on trial events as they occur. And that's all I have for you on this topic tonight. Remember, if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, my family is hard to kill, then you also owe it to yourself to make sure you know the law so that you're hard to convict. I remain Attorney Andrew Branca for Law of Self-Defense. Until tomorrow morning, stay safe.